Hi, everyone. Thank you for joining today's webinar presentation, Staying Relevant with Blockbuster Technologies. I'm Shelley Sombrio, Senior Business Development Manager at LexisNexis IP, and I'd like to cover a few things before we get started this morning. During the webinar, please feel free to submit questions using the questions feature in the control panel. Also in the control panel, you will see a handout section. This is where you can access files pertaining to today's webinar, including the webinar slides. A follow-up email of the recording from today's presentation will be sent to you tomorrow. Now I'd like to introduce our presenters. With us today, we have Kay Gruner, who provides counsel to Abbvie Pharmaceuticals and its affiliates on intellectual property, pharmaceutical manufacturing, marketing and distribution, regulatory matters, and commercial contracts. She earned her bachelor's degree in biology from Hiram College in Ohio, graduating with honors and joining Phi Beta Kappa. She then graduated from the University of Akron School of Law with her Juris Doctorate and LLM in intellectual property. Also joining us today is Dr. Sarbani Chattopadhyay. She is a computational biologist with a PhD in biochemistry from the University of Calcutta in India and a master's in European IP and IT law from the University of Göttingen in Germany. As a consultant at LexisNexis IP, she works with clients all across the globe in different technology fields, specializing in searching and analyzing patents, patent landscape, and technologies from a patent perspective. And last, but certainly not least, we have Jean Quinn. Jean is the founder of IPWatchdog.com, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Jean has been named one of the world's leading IP strategists by IAM Magazine. Thank you again, everyone, for attending today's presentation. And with that, I'll turn it over to you, Jean.
Great. Thank you, Shelley. I really appreciate you giving us the introduction, and thank you all for joining us here today. I think we hit a nerve. You know, we do a lot of these webinars which are general interest, and this one is more of a niche interest, and we had quite a sign up. So thank you for spending a portion of your day with us here today to talk about blockbuster drug technologies. It's an interesting topic. We've got some examples at the ready to show you what some very successful companies are doing in order to try and extend some of the most, well, actually one of the probably the most valuable drug ever, as well as another extremely valuable drug as well, blockbuster technology. And then Kay is going to go through and talk to us a little bit about some of the claiming strategies that are used to do this. So I think Sarbani, you're going to lead us off here today to give us some information about the business of doing this and why it's done, and the ramifications and the dollars that are involved, and lay the foundation for the conversation. So I will kick it over to you, and thank you for joining us again. I know it's late in the day for you, so we appreciate you being here.
Thank you, Jean, and thank you, Kay. I welcome you, and I welcome all in the audience for today's webinar. Yeah, as Jean pointed out, we would like to see and get some insights about the strategies that have been adopted by different companies which are owning blockbuster technologies to stay relevant in the market. It's not unknown to any of us that drug development in the pharmaceutical industry is very risky process. Just to put it into a perspective, in facts and figures, even if you get a patent granted for your drug, you pass through clinical trials. And the overall success, the probability of success through the clinical trials in the therapeutic areas, as you see, is not too high. The maximum is 33%. So even if your patent gets granted, there's no guarantee that you will pass the clinical trials. Even if you pass the clinical trials, you reach the market, there is no guarantee that your drug will be a blockbuster drug. It has to be prescribed, patients have to use it, so there's no guarantee in that. What is there as a guarantee is the cost. The cost to develop a new drug, as done in 2013 in a study by the Tufts Center for Study of Drug and Development, is 2.6 billion to develop a new drug in 2013. So the road to the development of a new drug is bumpy, risky, and very costly. So it's not really a surprise to us that if we come across different strategies that are adopted by the blockbuster technology owning companies to hold on to their blockbuster technologies. Let's just have a look at one of these kind of the technologies that we can look into. Our first example is Abbvie's drug Humira. Not something that is unknown to at least in majority of the people related to pharma. It has a lot of application areas. As the New York Times says, it can be applied to arthritis, colitis, psoriasis, and it is projected to be projected to be the biggest selling drug in the history by 2024. It is expected to overthrow Lipitor, which is, as long as, at least for now, is the best-selling drug of all time, Pfizer's blockbuster drug that recently expired in 2012. So Abbvie owns Humira, and Abbvie obviously has protected it through patents. Let's have a look at what patent analytics can tell us about Abbvie's strategy regarding the drug Humira. We have used LexisNexis patent site to get the charts for patent analytics. What you see here is the filing statistics chart of the patents that Abbvie has filed regarding the drug Humira. The few things that you see is the earliest filed drug is in 1996, and then there is a lull. And then if it's 96, the technical term of expiry is 2016, and during this time there is an increased filing activity. What we get from this filing statistics graph is also the current legal status of the drugs that have been filed in these years. In case we see the 96 drug to be in force right now, because patent site works at the patent family level, so this family has a document that has been filed later, but claiming priority to the 96 drug. That's why it is in force right now. Another thing interesting to point out here is there are some drug patents that are filed in 2017 and 2018. And that are shown to be in force. That means it is protected at least in some part of the world. That means with this Humira drug, Abbvie has been successful in protecting at least some aspect of the drug in 2017. So that part gets protected for another 20 years. So this is the strategy, the first thing that we get to understand from the filing statistics of Abbvie regarding Humira. At this point of time, we would like to have a feedback from our audience, and there's a poll question. So
the question is, on average, how many orange/purple book patents are associated with each drug? We'll give you about a minute to respond to this. The responses are still rushing in here. So 41% say somewhere between 11 and 20.
Yeah, so we can have a discussion about it in that session for this. Maybe Kay can tell us some insights about this already.
Yeah, so I'm actually glad to see that 11 to 20 sort of won the poll, because what it shows me is that the audience is definitely familiar with pharmaceutical patents and the general strategies. But I'll, if you go to the next slide and show the examples of the different patent claims, I can talk through those. But also just to, so from an industry perspective, one of the things you want to do is when you're sitting and coming up with your patent strategy, it's definitely not just about the core technology. The API itself is very important in the chemical structure, but as Sarbani, as you mentioned earlier, there are so many other hurdles that add so much time to the whole process of getting your drug actually approved, that oftentimes by the time that that drug is actually on the market, you've lost so much patent life from that original core patent. So you have that family, and then often a blockbuster pharmaceutical has even more than one patent family, that, and you keep it alive as you go. So thinking, what are the broadest possible claims you can get? And I can walk through the different types of them, but thinking through absolutely every aspect of the product and what could make it unique, and incorporating that into your claim set. So for pharma, for example, it's also very important to make sure that your label is in line with your patent claims, because when you have a follow-on competitor, whether it's related to Orange Book with small molecules, or whether it's Purple Book with the biologics, they're often needing to incorporate every or most aspects of the label. So if you can actually get claims around particular things in the label, like specific populations. So this chart gives a great breakdown of some of the most common claims that you see in pharmaceutical patents. So the molecules, of course, in the upper left, that's kind of like the core technology. And as you mentioned, the likelihood that any particular species is going to make it through all the way through trials and actually be approved and marketed is not super high. But once you get to that point, and after some of that patent life is lost, there are so many different ways to capture the value of that product. So processes, for example, that's manufacturing process of the API itself. It could be the manufacturing process of the final product. Purification method is in there. You can even add into your patent claims purity level. I've even seen claims around impurities that are necessarily created in a manufacturing process, that if someone else is creating a drug product, whether it's the API or the formulation, and they create these impurities, if you have patent claims around those, even that can be enforced. So that might not be something that's necessarily listed in the Orange Book, but it's this added protection, every aspect you can possibly think of to protect your product. So, and then down here under molecules, where it says compositions and formulations, compositions, this can be essentially a list of ingredients, relative percentages, certain features that that particular formulation creates, and that could be tied to things like increased bioavailability, increased efficacy, all sorts of things that an increased or a better formulation can have. You can absolutely, and here we have an example, extended release, gel patch, the type of administration route, so subcutaneous, ophthalmic, and then here we have what's calling other. And also I want to mention that, interestingly, in patent claim strategy, the molecules, that upper left here, when we're talking about that core technology, is considered kind of a primary patent and primary claims, and all these others are sometimes viewed as secondary, when in actuality I think that they provide so much comprehensive value for the product. So diagnostic tests, for example, and I'm wanting to see, I don't see it on this particular list, also assays. So any kind of characterization of your product, these are things that, as you're imagining, at some point someone's going to potentially come create a generic version or an alternative competitor version of my product. If you are also designing claims around the assays to show characterization of your product, that's another strategy to take as well. And this, we may touch on this a little bit later, but this isn't even exclusively brand strategy. This can be used by generic companies as well to protect their products. So corresponding devices, ancillary things like that. And then there are specific forms of molecules. Now, here in the bottom left, this is interesting and I think a little bit controversial sometimes, because you have the molecules, the initial core technology, and then sometimes as development goes on, you do find and isolate specific enantiomers and specific polymorph, that's a crystalline structure, and salts, esters, prodrugs. So these are the kind of things that as you develop and as your portfolio continues to grow, your patent portfolio and your product portfolio, you want to be aware that these developments along the way are and can be inventive enough to go ahead and get patent protection on, and it's absolutely worth trying. And One comment I have there I want to say is that when you're working with the patent office, listening to what the examiner, what is compelling to the examiner, because it may be a feature that you threw in there, made sure was in the spec, but didn't know that it would be the thing that the examiner wanted to, view as inventive. And let's see, making sure, let's see. Okay, so yeah, for uses and indications, this is another big one when it comes to, for example, existing compounds that the core technology, that initial patent family is long, long dead. You can definitely claim, and this is huge, new uses, new indications, and new dosage regimes, and making sure that you're calling out what is special about it, what's unique, how is the patient being served better by that new formulation, that new use, that new indication. And then patient subgroups, I want to make sure I mention that because that's a good one too.
Yeah, now that she has mentioned about the different types of patent claims, it's a good time to have a look at what Abbvie did with its patent portfolio regarding Humira. Let's see if what Kay has pointed out, if we see a similar thing when we do the analysis on the patents of Abbvie portfolio regarding Humira. So the first earliest filed patent, 1996, as Kay pointed out, it discloses that this patent can be used for the immunological disorders, dermatological disorders, as well as for the blood, for the urinary tract, for the metabolism. So this was already disclosed in the earliest filed patent of Abbvie. Towards the later part, when again the filing activity, as we saw, again revived, as Kay pointed out, a new formulation. This is an injectable preparation. If you remember the picture that we showed, that it is actually an injectable formulation. So the drug is in the form of injection. So this injectable formulation was protected later by a patent. Subsequent patents, as Kay pointed out, new indications. So the new indication for an application area of a sexual disorder. And most recent one that Abbvie has filed, it is regarding the non-active ingredient. So the active ingredient, as Kay pointed out, the API being already protected, the ancillary aspects are now attempted to be protected. Now, if this is the one that Abbvie has got the grant for, what it can do is it can prevent the exact formulation being brought to the market, even if its earlier patents expire. These are the strategies that seem to be adopted by Abbvie to at least protect its exact formulation as long as it can. We move ahead and we check some of the more, have an idea about the things that are happening around Abbvie Humira patent portfolio. What we see here is the companies, the top 10 companies that are filing patents, that are citing the patents of Abbvie's Humira portfolio and the years in which they were filed. What we see here is Abbvie itself is filing patents that are citing its own Humira patents. So that what we were, as Kay pointed out, that what we were saying, that it is building on its own drug that it has invented and protected through patents, that is Humira. The other companies that are citing patents of Abbvie's Humira drug patents are Pfizer, Amgen, Boehringer Ingelheim, and the filing time seems to be in and around 2016. Starting from 96, 2016 seems to be the time when the expiry of at least the major patents can be within the horizon. And this seems to be like a time when other companies are also building something in that area. This is something we understand when we look into the patents that are being filed by other companies. We also look into the entities that are opposing Abbvie's Humira patents, and we find that the companies that were citing Abbvie's Humira patents, like Amgen, Pfizer, they're also opposing Abbvie's Humira patents. So we can be sure that they have a legitimate interest in this area. There are other companies like the generic companies, Generics UK, Teva Pharmaceuticals, who are also opposing Abbvie's Humira patents. This is already probably known by Abbvie, and we also come to know about it through patent analytics. So now that we know that which are the companies that are citing Abbvie, which are the companies that are opposing Abbvie regarding Humira, this should not come as a surprise to us that Abbvie is having this strategy to hold on to its blockbuster drug as long as it can. So it is having a contract with companies like Mylan, Samsung Bioepis, Sandoz, Fresenius Kabi. You saw these companies as the opposing entities to Abbvie's Humira patents. Abbvie has dealt with this, the latest one being Pfizer, to delay the launch of Humira biosimilar until 2023. So this is the strategy that has been adopted by Abbvie to hold on to its monopoly to Humira as long as it can. The only company that has not signed this contract is Boehringer Ingelheim. It has, it's said to the Center for Biosimilars that it is focused in bringing the biosimilar to Humira to the market before 2023. At this point of time, if we look into the first slide, and when we said that Abbvie is projected to have Humira as the biggest selling drug throughout the history, tipping off Lipitor, now we understand the strategies behind it, that what are the strategies that it is taking to do that. Why I mentioned Lipitor again is Lipitor was the biggest drug, and it was a blockbuster technology for Pfizer. Such was its effect when it expired in 2012. Pfizer brought its generic form itself to the market. So this is another strategy taken up by the owners of Blockbuster Technologies to hold on to these. Now that we already have a discussion about generics, about the patent owning entities, maybe Kay can give us an idea about what are the legal provisions that are available to generics to have a market share.
Yeah, so at this point, a lot of patent attorneys, whether at law firms or even in-house counsel, whether they're patent savvy or not, are pretty familiar with HatchWaxman since it has been around for quite a while. But just as a brief overview, what HatchWaxman did was create the abbreviated pathway for generic versions of small molecule drugs to get to market more quickly by relying on data to have this pathway set out in order to resolve patent claims and issues at an early point before approval and before bringing the product to market as a generic. And the BPCIA is essentially a not parallel, but it is a similar pathway in that it is an abbreviated pathway, but rather for biologics. So when you have a compound that is approved as a generic version of a biologic, it's considered to be biosimilar and needs to be demonstrated and shown to be biosimilar to the reference product. And for the small molecule under Hatch-Waxman, instead of biosimilar, we would call that bioequivalent. So these two pathways, and BPCIA is continually developing. And what's interesting is we have heard of and talked a little bit about the Orange Book, which is a required patent listing for small molecule products. And not only does it put generic companies and the public on notice of what patents are tied to a particular brand product, it is required, and at the point of filing an ANDA to try to introduce a new generic into the market, at that point the patent litigation pathway begins. Whereas for BPCIA, the Purple Book is not actually a patent listing in the same way. The requirements are different, and it is continuing to evolve. There's constantly new information about how that's going to work, but actually the exchange of patent information between a brand and a generic company trying to launch a generic version is actually done privately, and those patents that will be litigated are more, it's called the patent dance is what I've seen it being called colloquially, which I think is kind of interesting, but that is actually done more behind the scenes. So it is not known at this point whether the Purple Book will become more like the Orange Book in any sense, but so some of the similarities though that I want to point out here and some of the key differences, you notice the stay, so this automatic 30-month stay of FDA approval, thank you for pointing that out, and then the no automatic stay. I think what's interesting about some of the differences is that before the biologics and biosimilar pathway was created, I think some of us were expecting it to be very parallel, very similar, and the fact that there are differences makes it a little bit more complex and a little bit more intimidating for a company who's maybe never considered creating a biosimilar. It is a whole new process to learn, but So that's one thing that's a little bit different. And the exclusivities between the sponsor exclusivity and the generic exclusivity, these are something that you want to get familiar with. But one thing that I think is very interesting between these is that we often do think of brand company versus generic company, and in fact so many brands actually have generic arms, and there are some companies that it's more equal than that, where it's not just a brand owning a generic, but a parent company owning a brand and a generic. So they're really just these pathways that are set out as tools for pretty much any pharmaceutical company to consider using in order to build their product portfolio.
So now that we have an idea about what Abbvie is doing, what the generics are doing, maybe it's time for us to have our next poll question.
Are you in favor of generics settling with brands? See, and I knew we shouldn't have done this. You just can't ask a room full of lawyers a question like this and give them that choice. It's like catnip for lawyers. If the question gives you an opportunity to select, it depends. It's just too enticing to check. It depends. And we had equal percentage, 22% say yes and 22% said no, and 57% say it depends. Well, that was pretty predictable, I suppose.
Yeah, but the thing is, we find a very extreme balance between yes and no. We should have another poll maybe if people can just write in the question section that if it depends was not there, what would you have done? But the thing is,
I mean, and it is interesting, and it's when we look at this, it's important to point out that what the Supreme Court did, and I think it was FTC versus Activists, right, where they said that it was it potentially an antitrust violation. They did not say that doing this is an antitrust violation, and I would, in looking at this with Boehringer not settling, you the whole market, they're going to move forward, and it's a complex case. I mean, I don't know how you could almost go and prove that it would be an antitrust violation. Supreme Court's great at doing that. They say, oh yeah, it could be. You lower courts, you go ahead and you figure that out. But first you have a patent case, then you have an antitrust case, then you layer that on top of multifaceted, highly sophisticated economic analysis dealing with blockbuster drugs, and it's not an easy case, and I don't think we're going to see a whole lot of those being brought. And certainly when they are, they're going to be hotly contested. And in this case, I mean, with Abbvie, $240 billion drug, I mean, they're going to fight whatever they have to fight to hold on to that. And before I turn it back to you, since I'm talking, listening to you ladies speak, the thing that struck me, and this didn't strike me when we were having our prep call, but it strikes me that the strategies that the pharmaceutical companies use in order to extend the patents is not terribly different than the strategies that you might advise any other company. They are science specific in terms of the claims structure, for sure. But when you have even an ordinary kitchen gadget, you always look and you say, okay, well, there's going to come a point in time when everybody who wanted that has already got it, and we can continue to sell it because maybe people will want it. But what's next? What are you going to brand that's going to be the next product in your line, or are you just going to be a one-hit wonder? And one-hit wonders are fine. They make a lot of money, but you don't want to be a one-hit wonder. And that really is at its basis what the pharmaceutical companies are trying to do. And really at its basis what every company is trying to do. When you hit a home run, you try and figure out how do I extend that home run so that it scores everybody in all the bases, I guess, to move the analogy forward.
True, and I agree with you that the strategies we are pointing out for the pharmaceuticals, but it's effectively or technically not too different from any other field. Now we had one kind of an example. Let's just move it to another example. Let's see if we can find something else, some other strategy maybe. So the next drug which is in our focus is Biogen's Tecfidera. It is a treatment for multiple sclerosis, and in 2013 it was approved by the FDA. And this is actually a chemical compound, dimethyl fumarate, which Biogen could prove that it can cure, it can be a treatment for multiple sclerosis. And at that time, it was projected to become a blockbuster, which it actually did. If we look into the patent statistics as we did for Abbvie's Humira, we will find that a similar kind of a trend is seen. The earliest patents being here, then there is a lull at this point of time, and then there is an increased filing in the recent years. So even 2020, there is a filing that by Biogen related to Tecfidera. The attempt is, as we discussed throughout this webinar, is similar to at least save, protect a part, an aspect of the drug. As Kay pointed out, there are so many different types of patent claims in pharmaceuticals. Again, as Kay pointed out, that the different focus areas can be of the patent claims can be different. And if you look through the years and the patents that are filed by Biogen related to Tecfidera, it already disclosed in 2000 that it can be used for as a non-central analgesic for immunological allergic diseases, and it is an ester for carboxylic acid. So dimethyl fumarate is an ester known. Next, as Kay had pointed out, that there can be new applications. So the subsequent patents were disclosing new application areas, as we see. And the latest, again, being something related to the non-active ingredient, that is a carrier formulation. So in 2019, 2020, the attempt is to at least to protect the formulation somehow, so that exact formulation can't be brought to the market. Moving ahead, when we look into the statistics of the companies that are filing patents that are citing Biogen's Tecfidera patents, we find Biogen at the top. So from the filing statistics up till now, it more or less gets validated that Biogen is building on its own patents related to Tecfidera. It's an attempt to keep Tecfidera patents alive and the monopoly alive, or something else. That depends upon what we do with the analysis. But there's an indication already. Some other companies that are actually involved in filing patents citing Biogen's Tecfidera are companies like Roche, BMS, and the filing is in the recent years more. Expected starting from 2000, the expiry is expected around this time. So whoever has a legitimate interest may be doing some research and trying to protect it around this time. However, let's see what Biogen is trying. We again have a look at the patent owning entities or entities that are opposing Biogen's Tecfidera patents. We find that there are generic companies like Generics UK, as well as the Organization for the Coalition for Affordable Drugs, who are opposing Biogen's Tecfidera patents. They want the generics to be able to have a market share. What we have pointed out here is we find Biogen also mentioned here. Effectively, this graph is telling us that there is a patent in Biogen's Tecfidera patent portfolio that has been opposed by Biogen itself. It can come across as some kind of a fault in the data representation, but we can have a look into it. There is one patent in that portfolio that has been opposed by Biogen. Let's have a look into that patent to see what is actually happening. This is the particular patent that has been opposed by Biogen, and this was not originally owned by Biogen. It was Forward Pharma patent that was later on co-owned by Biogen and Forward Pharma. LexisNexis patent site works with the ultimate owner concept. So according to that, this patent family is shown to be co-owned by Biogen and Forward Pharma, but actually this was Forward Pharma's patent. The next question that comes up Biogen had opposed this patent. Why did it have to acquire this patent? Let's see what the patent is actually doing. This is the patent that was filed, that is claiming priority to a 2005 patent, and it was published in 2014. It actually discloses the dosage, a daily dosage of 480 to 720 milligram of dimethyl fumarate to treat these kind of diseases. If this patent gets validity, it automatically invalidates Biogen's patent, which was filed in 2008, where it had disclosed the dosage form of 480 mg per day of dimethyl and monomethyl fumarate to treat multiple sclerosis. No wonder Biogen has to oppose this patent, because it is losing its entire monopoly over Tecfidera if this patent remains active. Biogen actually did not wait for the resolution or the result of the opposition procedure. What it did is now being shown as the biggest insurance policy taken up by a pharma company, because Biogen wants to protect its most valuable drug. So what it did is it had a $1.25 billion of agreement with Forward Pharma. However, please remember that the agreement does not resolve the patent dispute between the companies. So it didn't even wait that, it didn't even care that whatever happens, we will look into that later. What it was most interested is to use Forward Pharma's patents. That means whatever be the result of the opposition proceedings, Biogen has a right on Forward Pharma patent regarding dimethyl fumarate. So it has to seal its protection for Tecfidera, and it did that. Now, if you look into I have presented both. So this is how they presented the news in their websites. So what Biogen is saying is they have formed an agreement where they are to pay this amount of money to Forward Pharma's IP, and future payment of royalties are there subject to the resolution of the ongoing patent procedures. What Forward Pharma has disclosed in its website, its Biogen will pay Forward Pharma a non-refundable cash fee of $1.25 billion. And depending upon the outcome of the litigation and the opposition proceedings, Forward Pharma may be eligible to royalties on the sales of Tecfidera. Forward Pharma also mentioned the patent family that we saw in the last slide. And it also mentioned that the companies in this deal that they have sealed have not resolved the issues. They have left it on the PTAB and the EPO for their decision. And the decision that stands right now, the current news that we have is Forward Pharma has lost the case in both EPO and the USPTO. So this particular patent was revoked by the EPO after the oral hearing in opposition, and the US court upheld the PTAB's decision and freed Biogen from paying any royalty payment to Forward Pharma. So this insurance policy of $1.25 billion for Forward Pharma's IP that was done by Biogen was for nothing. But we are here to look into the strategies that are being adopted by companies and what they're doing to keep their blockbuster technologies protected and hold on to that. We find this is another aspect where they don't shy away from spending as much money as required for this. The other thing that also needs to be given as a news is, after all this, current news is Biogen still has lost its protection because one of its patents has been invalidated against a litigation procedure that was taken by Mylan. And Mylan is bringing the biosimilar of Tecfidera to the market. This is how, this is not something that is new. This is how the dealings go, and this is how the strategies are adopted. However, the thing is, even after all this, you may sometimes be successful and you may sometimes fail. What important thing that we see here is, when we started, we discussed that we have patents, and then we have clinical trials, and then we have a struggle to be a blockbuster, and then to hold on to our blockbuster. There can be a lot of discussions like what is the best procedure. We brought forward some of the procedures. We would look forward further to look into the future, what happens with Abbvie's Humira patents. because anyway, Boehringer Ingelheim will bring the biosimilar. So whether Humira becomes the most the best selling drug in the history or not, whether Biogen holds on to its share or suffers loss because of Mylan's biosimilar, we have to see. But today we saw the strategies that were being adopted and the insights that we get from patent analytics. And maybe we could show you some of the aspects that that can be obtained from patent analytics. And for today, the discussion, there's no more news or no more information, but we can always have a discussion right now about what we see and what we got from this webinar.
Great. Well, thank you, Sabrani. So now, Kay, this is an interesting strategy here, challenging the well, challenging is, I suppose, not so much the interesting strategy as much as it is when you have somebody who's challenging, then you reach out to them and you make a deal or you acquire. Are you seeing a lot of this type of activity today? I mean, once upon a time, you would see a lot of this kind of buying of smaller pharmaceutical companies, smaller biotech companies, but I have a sense that the market has changed for those companies.
Yeah, I don't know if it is the increase of options or increase in creativity or any combination, but the market is moving, and I think that a traditional generic approach of maybe a safe pathway and always using the same strategy is maybe a little bit of a thing of the past. And I think that instead of viewing a generic company as specifically that, I think we just have pharmaceutical companies and generic or brand products. And so you look at your product portfolio and it could be made up of any of those. And when it comes to the various routes of challenging patents or competing or working, whether it's settling or what it is, I think that it's almost that all is fair in love and war situation where these strategies are out there, and the opposition proceedings at the U.S. Patent Office, these type of administrative proceedings have been available outside the U.S. for a while. And while I think it's a point in time where generic companies may be sort of taking a little bit of power. And again, when I say generic company, I don't even necessarily mean to distinguish from brand companies. It's just maybe someone who has traditionally sought generic products are sort of looking at all of these various options and pursuing them.
Yeah, so because your company is, I suppose you would call your company a generic company, correct? Sort of.
Abbvie Pharmaceuticals is a generic company, and our sister company, Avion Pharmaceuticals, we are at a size and a point in time where I work with general counsel, I'm associate general counsel, and we advise to both subsidiaries. So I'm sitting in the room thinking through brand strategies and generic strategies on the same day within the same hour, because a product portfolio is essentially a shared asset. And we also have just recently in the past year or so acquired a manufacturing facility. So we have that in-house now and are currently working on packaging as well. So it's an interesting position to be in, but yeah, we're really focusing on all of it.
So where do you see the market going? I mean, is this a trend where and I guess, you know, just to some extent that there's always been this with respect to the brands, when the brand has had a enormously successful drug, at least, well, let me tell you my perception. You see, I think when a brand has got an enormously successful drug, as it gets close to the patent going into the public domain, then all of a sudden the brand starts working with the FDA, I suppose it is, and now this really doesn't need to be by prescription. This can really be safely administered over the counter. And then you get things like, like Allegra or those types of, like, I'm thinking the allergy things that I'm more familiar with, being allergy sufferer, that then go from being prescription only to now being safely administered over the counter, which seems to always coincide with the patent
Right.
expiry, right?
Yeah, and there is so many tactics, and that there is showing the value of not just a brand product in terms of the sort of back end of prescription and how people get certain drugs into their actual hands and bodies, but the value of the brand itself and the trademark.
That's absolutely right. And that's one of the things, not just for pharmaceuticals, but one of the things that always irritates me about what's going on more broadly in the patent space right now, where it's getting harder and harder to enforce certain patents, because a patent is a wasting asset. And if you can't enforce it, and it takes, a decade to enforce it in a lot of cases, where the trials don't take priority. And I get that, they can't take priority, certainly over criminal cases. And so, so the trial sometimes can take 3, 4, 5 years, and then the appeals, then it goes back down. And then, the damages always seem to be remitted by the federal circuit and then retried. And it can take, a decade for a lot of these important cases or more. And a lot of times the patent owner doesn't have that in them, but when they do, all the while, frequently the other the defendant's product has been in the marketplace. And as we know from the pharmaceutical industry, a big benefit of the patent is you get 15 to 20 years, however really long your product is in the marketplace. And I suppose for pharmaceuticals, sometimes it's less than that. Maybe it is only a decade because of the FDA processes, but you get a large chunk of time in order to build a brand. So then when the patent is gone, people still want your brand versus the generic. And that is very powerful. So, I mean, I guess the question here is, we know that brands have done that, and now and I suppose it's new, and maybe it's only new to me, being the electrical engineer on the panel, the moderator, but generics are getting more into the going the other way, not just doing the generic, but actually trying to get the patent and become a brand. How long has that been going on?
I don't know how long or how long when it started, but I definitely see more of it happening, and I think that it is a very interesting tactic for someone who's maybe, or a company that's more familiar in the standard generic pathway, to explore ways to create their own IP and sort of make a name for themselves, and have promotional materials as well that need to, of course, be reviewed with FDA regulations in mind, but to actually build a trusted brand, which I think is important in particular for companies that have large generic portfolios, because generics sometimes are viewed as having more quality issues or some sort of lack of trust when it comes to that lack of brand recognition. So actually a generic becoming a brand is something that I'm seeing a lot more of.
Yeah.
Yeah, actually it's true, because we now see Teva Pharmaceuticals filing a lot of patents recently, and they are, whatever they were, it seems, in the therapeutic area regarding the patents are also the ones where they themselves have brought in some kind of a generic. So that is one aspect where you are right, that generics are also trying to create a portfolio, a brand. The other thing is, as you said, that if you have a brand and the trust factor, so in that case, Pfizer's decision to bring the generic of Lipitor to the market itself seems to work, because it has been a wonder drug. It has given Pfizer the revenues that they're skyrocketing revenues. And once it expired, they did everything they could do. And then they went ahead to bring the generic themselves. So they brought atorvastatin into the market, and they are owning the generic form. So, and this seems to work, right? That if you have a Blockbuster If you can't prolong it anymore, you yourself bring the generic to the market. But how much can it affect the generic companies?
Well, in addition to having potentially that market share very quickly right away with something like an authorized generic that a brand company can do, there are ways to protect a formulation, for example, and as a generic company or for a company seeking to launch a generic, they can go through an alternative pathway as well. Basically get creative and look at all the options and see what may be possible with your development team and create a new formulation that has some improved performance, maybe so through, for example, 505(b)(2), where you are still relying on so much of the data and information and the work and time that a brand product had in its development, but you are actually creating a new dosage form. And maybe it has some benefit because, say, maybe it's a liquid rather than a tablet, and it's easier for personalized medicine. And so there's so many ways that a generic and brand companies or just pharmaceutical companies in general can sort of look at all the different options before them. And of course, there's the design around. So if a brand company, while it is pending and having its market exclusivity with its strong patent protection, whether it's 10 years or whatever it is, can be developing formulations in the meantime in a defensive manner. So as design around to make it harder actually for a generic formulation to come about. So even if that particular formulation that, say, a brand product has is not listed in the Orange Book because it's not the same formulation as the actual product that they have on the market, that patent protection is out there preventing others. And from a generic perspective, when you're in the process of deciding whether or not to put the money into developing a formulation, you don't just look at Orange Book patents. This isn't for a small molecule, for example. You do a search on all patents relating to and applications relating to a particular API. So if there is just an abundance of formulation patents out there or applications, and you see that it is not just Orange Book, but there's a whole patent portfolio that may block you, you may decide not to go with that option at all. So there's a lot of ways to sort of build your portfolio, whether it's brand or generic, to prevent others from joining as quickly as they want to.
Another aspect that Kay, you pointed out briefly when you were explaining is about what is called actually secondary patenting. And secondary patenting is something which is quite well known in the USPTO and the EPO. But there are other countries where this is not allowed. And since we are discussing this, for example, and I thought since we have some time, this was the famous case of Novartis regarding Glivec. And there was this huge case that was in the Indian Patent Office because they refused to give a patent protection to a better crystalline form of the drug. And this was a case that was discussed all over the world, and it was actually granted in USPTO and the EPO, but they didn't have it in India. The fact that not having it in India is because it is a market for generics. If it's not patent protected, it is open for the generic companies to prepare the product. There are other things, social things related to this, but this is also an aspect, whereas secondary patenting, and as we saw in the two cases, as you discussed, it is also a way of building a patent portfolio around a drug. But in case the law doesn't allow it, you are losing quite a bit there, aren't you?
Yeah, definitely. And I think when it comes to even formulations, at a certain point, the patent office is going to really demand what are the unexpected results here. So they need actual data, something supporting maybe increased solubility or increased efficacy, of course, would be great, and bioavailability in these things. But in not only that, but tied to something that is more than what one of ordinary skill in the art, who is every day developing pharmaceutical formulations, wouldn't take that step. So showing unexpected results. So I do think it's getting harder and harder in the US as well, which is why it is so important to sort of constantly keep your patent family or families alive. And every time someone on the technical team, or if you have a CDMO working on your products, comes up with some new concept or some new idea that has any connection to a product that's important to your portfolio, file a patent application or file a new continuation, because it's another, when we mentioned just briefly about the different opposition proceedings or even patent litigation or settlement, the more patent protection you have, the more likely you're going to be able to keep something from it. Because if you're relying on 1 or 2 or 3 patents and those are invalidated for maybe even something like the claim not being not necessarily supported by the spec, but something that you would almost view as procedural, that's a huge loss. It's a massive loss. So to making sure that you have multiple, diversifying really your patent portfolio.
Yeah, so it makes sense to have a diversified portfolio around a drug. Another thing that the patent blockbuster technology owning companies can say is, we are the ones who bring in all kind of incrementational innovation regarding this drug. We are the ones who are spending on the R&D and continue to spend on the R&D and bring the so-called unexpected results. So why shouldn't we have a monopoly on the results that we have? This is not something that I'm trying to make a statement. I'm just putting forward that whilst we all want that there should be a trade-off, a balance between a monopoly and the availability and the accessibility of the drugs, it is also true that a lot of, as we discussed at the beginning, a lot of money is being spent, and a lot of money is being still spent by the ones who are actually holding the patents, and they are going on doing researches. What if the generics come up with some new unexpected result and protect it? Then the situation changes, and then that's fair for all. Can that happen?
Yeah, absolutely. And I think it very much is happening. And I think that it's important for anybody who may not be thinking about this in their own assets to think of how they can protect whatever particular anything that could make them unique or prevent others from essentially either following on their product or creating something to compete with it later.
True.
Okay, well, I'm looking at the time, ladies, and we're just about at the end of the hour, and I'd like to give each of you an opportunity to wrap up with your final thoughts. Sarbani, how about you go first? What is the one thing that you hope that people leave today remembering?
The one thing that we wanted to point out is, if you monitor the patents that are being involved regarding a particular drug, a particular pharmaceutical entity, there is a lot that you can understand. The aim of this webinar was to show how patent analytics can give you an insight about what's actually happening in the current scenario. I mean, this is not something that we did a back calculation. We actually found, and then we went to the news and we found that, okay, so this makes sense. So starting from the initial point, which is patents, monitoring that, you can understand what's going on. And I will be very happy that if this message goes across the audience, that you can do patent analytics to have an understanding of the current scenario as well.
Great, thank you very much. And Kay, what is the one thing that you hope people remember as they leave here today?
I think the one thing would be to, if anything, feel empowered to know that these various strategies and tactics that are out there, that it's not necessarily available to one particular group or one particular type of company, and that in fact there are so many ways to build your portfolio, and it's so important, especially if you maybe are at a stage and a size of company where you kind of rely on 1 or 2 big products, to think of how you can expand that portfolio in a way that maybe you didn't traditionally think your company was going to be moving in that direction, because it's really based on the product itself. So, and I think that the patent analytics, to Sabrani's point, is important because you can essentially look at others as case studies and be empowered and inspired by that and apply it to your own portfolio.
Great. Well, thank you very much. I really appreciate you taking the time to join us here today. And thank you all in the audience for spending the hour with us here today. Hopefully you learned a bit about Blockbuster Technologies and Humira in particular, and what Biogen is doing as well. And hopefully you'll join us again here in the future. But for today, that's all we have. You all have a good rest of your day and a good week ahead, and we'll see you soon. Take care, everybody.
Thank you.
Thank you.